first page, it said this dictum soon became law. So when did that dictum become law?
From a historical perspective, Your Honor, I believe you
I
have
want a case, if you've got a case where that dictum was adopted by any court of this state since that day.
Your Honor, I believe that dictum was adopted in Montgomery versus Cleveland, where in Montgomery versus Cleveland, the court said, and I quote, "He is the sole judge of the sufficiency of the facts and the propriety of granting a pardon, and no other department of the governor has any control over his acts or discretion in such matters."
Montgomery court also said that publication had been followed through with and was completed.
That was based on stipulated facts, Your Honor, and in that case, that was not an issue.
But we don't know if the Montgomery court would have had the same conclusion had it not been so.
But this, I think
hence first impression.
Yes, Your Honor.
All right.
And I will say that the historical facts demonstrate that the Mississippi legislature concluded that that is what the court meant, because the following year, and let me go back just a second and say that in 1916, the Mississippi legislature created what was called the Pardoning Board. And the Pardoning Board was created to, among other things, define how you comply with Section 124 of the Constitution and its publication requirements. I have that statute, and among other things, that statute said that not only shall you publish 30 days, it said that it shall first require the person applying for a pardon to publish the application, therefore, for 30 days. It said, in an application so published shall set forth the reasons why such pardon should be granted. After the board met, it would publish, that person would publish again. That person would publish by posting the same in 3 conspicuous places in the county, that the second publication shall state the grounds, and that it was to be advertised by, according to that act, for 60 days before it was to be considered by the Board of Pardons, that it would have a sworn affidavit attached to it, among other things. Well, that statute that was adopted in 1916, after the Mississippi Supreme Court rendered Montgomery versus Cleveland, the very next year, the legislature, in view of that statute, repealed the statute. They repealed it and did not approach the issue of whether or not the governor had pardoning power and how to approach publication under Section 124 until 1944, when the legislature went back and created the current state parole board. But in the statute creating the current state parole board, the legislature said specifically, for the first time under these statutes, and I quote, "Nothing in this title or the sections of this act shall be construed to impair or limit the power of the governor of the state to grant pardons or commutation in any case, or in any way impair or revoke such good time allowances as is or may hereafter be provided by law," end quote.
But at the time that they repealed the earlier Pardoning Board, they did not amend the Constitution or seek to amend the Constitution to remove the publication requirement from Section 124, did they?
That's correct, Mr. Justice. And the reason that I contend they did not remove the provision is because that provision was subject to separation of powers. And the statement that the legislature was making by enacting, first of all, repealing that section, and by enacting the following section, which expressly recognized the right of the governor as an independent branch of government, as an independent branch of government to deal with that issue, was that issue on the separation of powers was supposed to be under the sole discretion of the governor, except to the extent that the Constitution provided that that power would be checked by the Senate in specific circumstances.
But going back to the question I asked earlier, we're looking at the act, not of the governor granting a pardon, but looking at the act of the convicted felon who has the responsibility to publish. Does the governor have the right to waive that publication requirement imposed upon the felon by the Constitution?
Your Honor, Mr. Justice, I can answer that question, but let me first explain.
I didn't get an answer the last time I asked that question.
I'm definitely going to answer it. But let me say that I believe that the question needs clarification, because the history of the state of Mississippi suggests that it is not necessary for the convicted felon to apply for a pardon. In fact, someone could apply for a pardon on behalf of the convicted felon or the governor could grant a pardon to a convicted felon based on no application at all. Now, in the instance in which a convicted felon applies for a pardon, I'm not suggesting to this court at all that there is no publication provision in the Constitution. What I'm suggesting to the court is that under the separation of powers provision in the Constitution, that the power to determine whether or not that provision of the Constitution related to publication has been complied with rests with the third branch of government, the executive branch, and the chief executive of the executive branch.
Well, I'm a little confused by the facts and reading what transpired in the lower court. Have the files of the mansion pardon individuals, have those been produced?
Yeah, I simply cannot answer whether the files have been produced or not. I don't believe the record reflects one way or the other whether or not they've been produced. I will say that to open the Pandora's box of producing records from one branch of government to the other branch of government and subpoenaing documents as it relates to the governor's exercise of pardon power is part and parcel of the problem that you run into when you have one branch of government invade the other branch of government's province.
We look at Department of Correction files all the time. I would assume when a person moves from Parchman to the mansion that there's a file on that person.
Your Honor,
that pre-existed them being at the mansion. So I raise that because of your statement of this separation that these people didn't apply, because I'm looking at the publications they made later, or not within the 30 days, and it says they did petition for a pardon, and yet I'm being told in y'all's briefs they didn't petition for a pardon. So which is correct?
Well, Your Honor,
the publication in the newspaper or the position being taken in the briefs that they never asked for a pardon?
Your Honor, the governor was never asked by the mansion trustees for a pardon. With respect to the record in this case, I believe reflects that the governor's position has been from the beginning that the pardons that were given to the mansion trustees were based on living files. That is, the right of the chief executive and the folks that he delegated at the mansion to watch and observe these individuals over the time that they spent as basically servants at the mansion, and that based on that observation and other matters which were in the sole discretion of the chief executive, that is the governor, that he decided to exercise the power of mercy and grace and grant a pardon.
And the 5 trustees at the mansion never applied, is that correct? I mean, they are non-applicants.
They're non-applicants.
And the other 5 before the court did apply, is that correct?
Yeah, I cannot speak for them.
Well, I mean, that's not really here or there, but Mr. Griffin. But let me go ahead. Now, you make an alternative argument in your brief, which it really does intrigue me, regarding harmless error. Could you go there and explain how you would apply a harmless error analysis, assuming for the sake of argument that there was a constitutional violation?
Correct. Assuming that the issue was justiciable, which I do not concede, Your Honor, the concept of harmless error is a concept that's argued before the Mississippi Supreme Court almost every day by the Office of the Attorney General. And it's argued because in criminal cases and in cases in which the Constitution is applied, you are not guaranteed a perfect trial or a perfect process. You're guaranteed a process that is going to be as perfect as it possibly can be under the Constitution, subject to the need for finality. And if there is no substantive right that has been violated, if there is no prejudice that results from a arguably either failure to comply or partial failure to comply with a constitutional provision, then there has been no damage, there's been no harm, there has been no suffering which would require redress of
Would you agree that in the criminal context, as you point out, where the court is usually called upon to apply harmless error analysis, that those are really fact-driven, case by case, regarding whether there was harmless error? Would you agree with that?
Well, I would agree partially, Your Honor, but I would add to that that the primary question is always the same, but for that violation or partial violation, would the result have been changed?
Do you feel like that if we should get to that point, again, assuming for the sake of argument a constitutional violation and then a harmless error analysis, that do you feel like the record is sufficient before us to be able to make that decision as a matter of law?
I do, Your Honor. And the fact of the matter is that in order for the state to carry a burden to demonstrate that the result would have been different, the state would have to demonstrate that the governor, who I stand here for as amicus curiae counsel, would have made a different decision had there been publication.
And if we did that, then would we not then be getting into, in essence, the propriety of the pardon, which, according to the Constitution, we have no authority to do?
Absolutely, Your Honor. You would be getting into the deliberative process that the Constitution has expressly reserved for the governor, and that is why, at the end of the day, there's no way for the Attorney General to meet his burden. He simply cannot meet the burden of showing that there would have been error, which would have been harmful, because he cannot go beyond the constitutional power of the governor to use the deliberative process to grant grace in any manner and for whatever reason that the governor sees fit.
Mr. Griffin,
Yes, Your Honor.
we have addressed, or at least the issue is argued by Mr. Fortner, that no pardon shall be granted before conviction is something that would be effective, or would make the face of the pardon violation or subject to review. But explain to me the difference. No pardon shall be granted before conviction, and no pardon shall be granted until the applicant thereof shall have published for 30 days. What is the difference in those two no's, in those two provisions? Why is the governor, at least according to Mr. Fortner, subject to one and not the other?
Yeah. First of all, let me state what our position with respect to each of those is from an amicus curiae standpoint, Your Honor. With respect to the publication provision, it is our position that the publication provision is a procedural provision that is part of the deliberative process that has been delegated by the Constitution and the citizens of the state of Mississippi to the governor. However, the provision with respect to no pardon shall be granted before conviction is a substantive provision that applies to the individual to which the pardon may be granted. And in the instance of a failure to comply with that provision, it would be apparent on the face of the pardon. Because on the face of the executive order, granting the pardon, it has to reflect the conviction and the conviction date. And it would be apparent on the face of an executive order granting a pardon where there was no conviction, that there is no conviction listed. And so that would be invalid on its face, and it would be the duty of a court at that point in a proper proceeding to examine it and to say that this is invalid on its face. It's unconstitutional.
Griffin.
Yes, Your Honor.
You used the term executive order, and it reminds me of a question I wanted to ask you. As the governor's counsel, you may be in a position to answer this. These pardons, as I review this record, these pardons, we use the term pardon, and I'm not sure I know what it is in terms of the actual document or thing. I've got a collection of executive orders where the governor signed an executive order ordering a pardon. And for each one of those, I've got a document issued by the Secretary of State's office that notifies the public that a pardon has been issued. I'm not sure I know what the actual pardon is, and it could be important because they have different dates. Executive order has one date, and the document issued by the Secretary of State's office is dated 10, 15 days later. And assuming, for the sake of argument, that the number of days of notice or publication becomes an issue here, or controls the case, it would be important to know when the pardon was actually issued. And I'd like to have your view on whether it's the signing of the executive order that grants the pardon, or when the governor signs the. I have two questions for you. Is it the signing of the executive order that is the actual granting of the pardon, or when the governor signs the executive order and sends it to the Secretary of State, and the Secretary of State issues the document, is that the issuing of the pardon in your view? And first, let me just ask you to answer that question.
Well, Your Honor, with respect to the pardons in this case, and I've only seen one type of pardon, and that has been the executive order which recites that a pardon has been granted, it's signed by the governor, and it is attested to by the Secretary of State as being an official document from the governor. That is my understanding of what constitutes the pardon.
The pardon is the executive order.
As attested by the Secretary of
All
State.
right. Then secondly, in your view, since it is an executive order, does that, in your view, does that executive order continue to have full force and effect of law even after the governor leaves office? It's my understanding that when the President of the United States or a governor of a state signs an executive order, that executive order remains in effect until it's set aside by their successor in office.
I think that the character of an executive order would change once the word pardon is affixed to it, and once the governor signs it saying that this is a pardon. I don't have any independent research, as we said it today, on that point, because I didn't see it as being one of the issues in the case. But my understanding, just as I stand here today, Your Honor, is that once the governor affixes the word pardon and indicates that this is a pardon, and the pardon on its face, whether it includes the language executive order or what, is attested to by the Secretary of State, that is sufficient to constitute pardon under the state of Mississippi's law.
Mr. Griffin, you had indicated earlier, I believe, that the trustees were not applicants, correct?
That's correct, Your Honor.
But there was some discussion in your brief regarding kind of the communication between the governor's office and Attorney General's office regarding ensuring that the trustees were properly published. Is that not correct?
That is correct, Your Honor.
So if they weren't applicants, why would you need to have the communication to publish for them?
The way that communication and that discussion took place, Your Honor, was through communications between the Attorney General's office and the Governor's office. The Governor's office was advised that that the mansion trustees should be published by the Attorney General's office, and in an abundance of caution, they went ahead and asked that the Attorney General's office, acting through the special assistant who's assigned to the Department of Corrections, David Scott, go ahead and implement whatever he felt was necessary to accomplish that.
I know you probably can't answer this question fully, but is that the normal procedure where the governor's office contacts the Attorney General's office to assist in following the proper protocol in pardon cases like these?
I